So, all right, we have a few minutes left here. Let's talk about just compensation. All right. So what's the rule here? Well, there's no problem with the government taking or damaging private property. There's nothing illegal about that, right? Only if it happens, the entity has to pay just compensation to the private property owner, right? So what's that mean? Well, fair market value is the general rule most of the time. There is an exception, however, to cost to repair the property. We don't have time to get into that, but you'll see that if you ever practice these types of cases, you'll see that exception, all right? This, unlike the other issues we talked about, is a question of fact, right? And it's a right to jury trial on that issue. You may recall one of the first slides when we talked about Article 1, Section 19 of the California Constitution. We quoted it in full, and it talked about the issue of just compensation being decided by a jury. So this is the factual question, all right? It's based on what was lost. So you look at fair market value. Compare that to eminent domain analysis, right? So that's when, the government would come in and they want to condemn a property because they want to use it for, public use. In that context, the court has to, the entity has to come in and there has to be some agreement as to what's the fair market value of the property. Same thing here in the inverse condemnation context. But again, coming full circle to what we talked about in the beginning, you need physical damage to the property, right? That's a definite requirement here. The damage simply cannot be a depreciation of market value, right? That's not enough. The case law is clear about that. So again, coming again to full circle what we talked about in the beginning, as to ownership, any person with a property interest in the property is entitled to recover, okay? So what are the recoverable damages? That's the second question here. Well, if the property was completely damaged, wiped off the map like we saw back in Hurricane Katrina, fair market value on the date of the taking, okay, are damaged. If it's not completely damaged, then you're entitled to the diminution in market value, all right? Remembering, as always, you have to have physical damage to the property. Now, like I said, there is a cost to repair exception. If you litigate these cases, you will come across that. You also get interest from the date of taking or damage. Now, this is the explosive issue of inverse condemnation. And I think it's what drives a lot of these cases, is under Code of Civil Procedure 1036, the plaintiff is entitled to attorney's fees and costs. So what that means is this is arguably a potent weapon for the plaintiffs, and it's something that the defendants know if they're faced with a legit inverse condemnation case, is that the plaintiff is entitled to attorney's fees. Now, case law, I think there's a recent case that just came out and clarified this issue more, and I forget the name, but the attorney's fees that are recoverable under inverse condemnation have to be strictly tied to the work done on inverse condemnation, right? So like I said earlier, when I have these cases, I'll sue under inverse condemnation, dangerous condition, trespass, and negligence. But I have to keep up with my time as it's related to the work I've done to inverse condemnation. Okay, you have to separate that out, right? So that's going to be important, because some cases have come out and said, look, you can't just take a carte blanche move and say, give me all this. No, you have to show this is the fee related to the work you did on inverse condemnation. All right. Now, what you will see if you start to look at these cases is sometimes these costs and attorney's fees are higher than any of the hard numbers that the plaintiff, the property owner, gets, right? You could have a fair market value case of $20,000, and for whatever reason, the case stretches on for a year and a half, and you have to hire engineers, you have to hire hydrologists, and all these costs start to add up. So you can have $20,000 hard numbers, you can have $120,000 in attorney's fees and cost, right? So now, what's my math? $150,000 case? You went from a $20,000 case to a $150,000 case. So that's why this is such a hot topic issue. We'll talk about this very briefly at the end. because of the potency of the attorney's fees and cost under Code of Civil Procedure 1036. So lastly on this slide, subrogation. I spoke about the Pacific Bell, how that was brought by the insurance company. And you see that a lot. There's case law that came out that said insurance companies have a right to subrogate and to collect not only what they paid, also for attorney's fees and costs under CCP 1036. So that's a huge business, and you see insurance companies doing this. And I would say that that's what you see in PG&E's bankruptcy. Okay, so that brings me to the last slide here, and we'll talk a little bit about that. So, conclusion, what's the landscape going forward? Well, we limited this discussion, intentionally so, to water damage. Because like I said early on, this is a very confusing area of the law, and it's very nuanced. And it's changing, right? I mean, you saw this with the City of Orville case that just recently came out, and I would say just kind of changes the course of inverse condemnation. Now, let's talk very briefly about what happened to PG&E. So if anyone's picking up the paper, you realize that PG&E, a huge utility company, recently filed for bankruptcy following these devastating fires. And I would say there's an argument to be made that one of the reasons that PG&E did that is because of a very serious concern for plaintiffs and insurance companies, insuring those plaintiffs, coming after PG&E for inverse condemnation, the attorney's fees and cost, right? So let's go back to this example I talked about. PG&E could have had a $25,000 damage, property loss, or could have paid and be done with it. But now, under inverse condemnation and CCP 1036, that $25,000 case is now a $150,000 case. So you multiply that by hundreds and hundreds and hundreds of claims, and you get to where PG&E is, in my opinion.
The second code is 867. The second code is 867. The second code is 867.
So, very quickly, some of you astute listeners may say, well, PG&E is not a public entity. Well, that's correct, right? But there is case law that says when you have quasi-public entities like a utility company, they are liable for inverse condemnation, right? And I'm fighting that in one of my cases, and you see that in one of the wildfire cases that I have where it's an inverse condemnation case, right? And they're coming in and saying, look, we're not responsible, we're not a public entity, and frankly, they're losing the argument in court because the case law is starkly clear that in those contexts, utility companies are considered public entities for purposes of inverse condemnation, all right? Now, like I said, the attorney's fees and costs recoverable under CCP 1036 can make these cases almost a multiplier of hard numbers of recoverable damages, and that's what can make these cases so dangerous to defend and important for the plaintiffs. Real briefly, what you also see too by utility companies and some other interested parties is they're trying to make changes through the legislative branch in order to change this law. And you also see an attempt somewhat in the judicial branch to do that. The problem is that inverse condemnation is a constitutional claim. So if the law has to be changed, arguably the California Constitution has to be changed, right? But what you're seeing instead, at least at this time, is courts becoming a more conservative, restrictive approach when they're looking at these inverse condemnation cases. And so you see, I see the best example of that is what you saw in the City of Orville, which again I would say represents a move away from the traditional strict liability analysis of property ownership, property damage caused by an entity's substantial participation in a public project, over to, well, all those things are given, but let's see if what the entity did was unreasonable, or was it reasonable? And so I would say that opens up a little bit of discretion to find that these entities were not liable. So I would say from a plaintiff's perspective, that starts to make these cases more difficult, and my opinion would be the City of Oroville is a decision that's going to be relied on very heavily by defendant public entities in these cases going forward. But not to leave on a sour note, here we have clips of our buddies Dennis Hopper and Kevin Costner and the lost 1990s gem of Waterworld. If you haven't seen it, please treat yourself to it, and we'll leave on that note. Thank you.